All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so we are on March 14th, 2024 today, and that means, as we've talked about on the program several times, March 11th, earlier this week, the new National Labor Relations Board rule was set to take effect regarding joint employer status. We've talked about this on the program, and so that was supposed to go into effect Monday of this week. On March 8th, last week, a judge from the U.S. District Court for the Eastern District of Texas blocked the NLRB's expanded joint employer rule that would have made it more likely for employers to be deemed joint employers. The NLRB's 2023 rule that they promulgated late last year would have expanded the joint employer rule and created a risk that entities could be deemed joint employers over workers of a separate company. And it tried to simplify the joint employer exercises or retains the right to exercise direct or indirect control over a large range of businesses. The rule did not contain, very importantly, it did not contain carve-outs or exceptions for certain industries or make clear how it would impact common business relationships, particularly regarding the construction industry, franchisors, staffing agencies, and healthcare companies. And so the judge last week in Texas struck down this rule. Not to be totally dissuaded, the NLRB is reportedly exploring its options on whether to appeal. But I think the clear message here is again, under the Biden administration, they are looking for ways to construe separate employers as joint employers. Again, think of your staffing agencies, possibly other independent contractors. The administration's looking for ways to construe these folks as joint employers. And so that could impact things from unionization and minimum wage and those types of things. So be on the lookout for developments.
Does this mean us who are working outside of the state of Texas need to do anything different than what we're planning to do?
Yes. So this one's a little different. We talked a couple weeks ago about the Pregnant Workers Fairness Act and what a judge in Texas did and said that law did not apply to Texas employers. But that judge stopped short of saying it didn't apply nationwide. This one's a little bit different because this judge said that the NLRB's new rule is ineffective. And so again, with respect to this new rule nationwide, this did not go into effect this week. Okay.
All right. So we're on a pause at the moment.
We are on a pause, but not to be outdone. Also this week, shifting gears from the National Labor Relations Board to the Department of Labor. Also this week, this one is not stopped. This one did go into effect this week, is the DOL, we've talked about numerous times on the program, issued a new rule on independent contractors. So this is a little bit different than joint employer, but very related. So the Department of Labor's new independent contractor rule did go into effect this week. And again, just as a reminder, we've talked about it on the program many times, under the totality of the circumstances analysis, which is the new analysis that employers are being directed to use, employers are to consider 6 factors when determining how to classify a worker, whether they be an employee or an independent contractor. The 6 factors, I'll cover them really quickly: the degree to which the employer controls how the work is done, the worker's opportunity for profit or loss, the amount of skill and initiative required for the work, the degree of permanence of the working relationship, the worker's investment in equipment or material required for the task, and the extent to which the service rendered is an integral part of the employer's business. So unlike the prior rule that had placed considerable weight on 2 core factors, which were the control of the work and the opportunity for profit or loss, no single factor carries greater weight under this new rule. So the factors don't look that much different than before. It's just the weight of the factors. Under this new analysis, the totality of the circumstances analysis, They take what's called an economic reality approach to classifying workers, and it considers this non-exhaustive list of the factors I just covered, plus some other relevant factors that we'll see how they develop through the case law and the administrative process. So that one did go into effect. So we moved from the NLRB to the Department of Labor, and I just want to make sure that everybody's ready for this. I want to stick with the Department of Labor for one other issue. The Department of Labor also has finally issued its new rule. It's published its rule on. I'm sorry, it didn't publish it. The Department of Labor recently submitted its proposed final rule through the administrative pipeline on overtime. And under this proposed rule, the salary threshold, what people are expecting is it's going to move from roughly $36,000 per year to $55,000 per year. So that's going to be a very significant change there. This new rule received more than 55,000 comments, including a lot of pushback from businesses that would have had to consider adjusting employee classifications or compensation. So just bear in mind that this final rule has been submitted to the administrative process. We are expecting that it could be published as soon as April, so as soon as next month, and we'll have to see where they draw the lines on the compensation, the salary threshold.
Yep, absolutely. Those are some big changes for us to deal with.
Huge changes.
Yeah. So while our government's busy doing that, they're busy talking about TikTok and whether or not to ban that or not. So it's quite interesting, all the different things going on there out of our channels of government. All right, so Burt, as it goes, we did have a question come in on our YouTube line, and it basically is talking about the specifics of reclassifying contractors in the trucking industry. And I don't like to ignore comments that come in. I think that's something we can probably get to, but maybe not necessarily today.
Well, let me just give a 30 seconds on it. So that question goes to exactly what I was talking about before, which is the Department of Labor's new independent contractor rule that went into effect on Monday. And so all I can say without doing a specific analysis for the individual who asked the question is that, yes, the independent contractor relationship with the truckers is going to have to be examined. It does apply to the trucking industry. And so you will have to go through and analyze those 6 factors that I just covered under this economic realities test, the totality of the circumstances test. Just know that there is a lawsuit that was filed in Louisiana. It's the most recent challenge to this rule. It was filed on February 8th, 2024, filed on behalf of the owner of an independent trucking business that relies on contracting labor. The trucking business contracts with more than 30 owner-operated truck drivers and pays them a flat percentage of the shipping fee for each load they haul. The trucking business in that case argues that the new rule threatens to upend its business operations, increase costs, and potentially drive many of the truckers out of business or into different lines of business. So we'll have to see. Again, that was just filed literally a month ago.
Well, it's a good thing that Uber and Lyft would not make that same argument.
Yeah, exactly. So this case was filed a month ago, and we'll have to see if it has an impact on the enforceability of this new rule. But sitting here today, right now, this new rule is in effect.
Yeah. So if you have more questions around that, I'm not sure quite exactly who submitted that, but you can give us more detail, and we'll continue to try and uncover that and talk more about it as we can. The more detail we have, the better we can help you with finding your way forward, as we like to say. All right, Burt, thank you for that.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.